Okay, let's dive right into this. Welcome to This Explainer, where we take complex legal shifts and break them down so you can get straight to what actually matters. Today, we're unpacking a massive development from the highest court in the land, the Supreme Court's 2025 rulings on who exactly gets to be a judge. And look, this isn't just bureaucratic red tape. These are fundamental changes to the career paths of thousands of legal aspirants, literally shaping the future of the judiciary itself.
Here's our roadmap for today. First, we'll look at the principle of experience, then the 3-year rule for civil judges. Third, the bar quota for district judges. Fourth, we'll explore the counterarguments. And finally, the big one, the need for stability.
All right, starting off with Section 1, the principle of experience, or really, the foundation of judging.
Now, before we get into the 2025 rulings, we got to talk about Articles 233, 234, and 235. I know, it sounds like dense legal jargon, but what do they mean in plain English? Essentially, these are the constitutional provisions that link eligibility for a judicial office to demonstrated, practical exposure to legal practice. Think about it. Judges are making massive decisions that impact human liberty, property rights, and the delicate assessment of evidence. So the law essentially demands that practical courtroom exposure has to take precedence over mere book smarts. You can't just know the theory. You really have to know how it plays out in a real, living, breathing courtroom.
Moving right along to Section 2, Civil Judges and the 3-year rule.
So, the crucial point here really boils down to a single number, and that number is 3. The Supreme Court has officially restored a minimum 3-year bar practice requirement as an absolute precondition for anyone wanting to take the civil judge recruitment exams. This is a game changer, guys, because it completely reverses the more recent trend of letting fresh law graduates enter the judiciary directly out of college.
You might be wondering, why reverse the trend? Well, because there is a massive gulf between a classroom and a courtroom. Sitting in a lecture hall doesn't exactly teach you how to handle a hostile witness or assess live, unpredictable evidence on the fly. A trial judge has to manage incredibly volatile courtroom dynamics and understand client handling from a purely practical perspective. The court basically found that allowing direct entry for fresh grads was producing judicial officers who were, frankly, just less equipped to handle these incredibly demanding day-to-day realities of the trial court.
But, as you know, whenever you change the rules of the game midway, you have to protect what we call reliance interests. That's just a fancy way of saying we need to protect the plans people made based on the old rules. So, while fresh law graduates now absolutely must practice for 3 years, the court specifically exempted existing, already appointed officers from this retroactive application. It also exempted lateral transfers, meaning officers moving between states. This was a deliberate, calculated move to avoid unfairly punishing those who had already successfully entered the system under the old guidelines.
Okay, Section 3, we're looking at district judges and the bar quota.
As we move up the judicial hierarchy, that magic number we talked about shifts from 3 to 7. For the bar quota, the requirement is now 7 years of advocacy. But this 2025 ruling introduces a very specific twist to this requirement.
Here is the nuance you really need to grasp. The court essentially overturned the previous stance set in the Dheeraj Mor case. They ruled that in-service judicial officers who have 7 or more years of prior advocacy experience, meaning experience from before they even joined the judiciary, can actually apply for district judge roles under the bar quota. And crucially, this 7 years of experience doesn't have to be continuous right up to the exact date of their application.
And this brilliantly illustrates the court's strict textual approach. The court reasoned that Article 233(2) simply requires 7 years as an advocate at some point in a person's career. Excluding current judicial officers who already had that 7 years of advocacy under their belt before they put on the robes, well, that would just arbitrarily shrink the talent pool. By allowing them to apply, the court argued that it actively promotes merit and brings a really rich diversity of experience to the district judge bench.
Which brings us to Section 4, Counterarguments and the Unintended Consequences.
So, we have to ask the hard question. Does this system actually work for everyone? You know, when we talk about high-level constitutional ideals, it is so easy to lose sight of the human cost on the ground. Thousands of aspirants structure years of their lives, their finances, and their families' futures around these exact exams. When the criteria shift this dramatically, real people are heavily impacted.
There are really two main fronts to this pushback. For the civil judge ruling, the primary critique is socioeconomic. The big concern here is that forcing candidates into 3 years of litigation creates massive financial barriers.
On the flip side, the district judge critique focuses on structural integrity. Specifically, critics worry that the new bar quota ruling blurs that vital line between direct recruitment from the practicing bar and internal promotion-based elevation from within the judiciary itself.
Let's break down these unintended negative impacts, because they're quite specific. First off, oscillating criteria creates severe uncertainty for aspirants just trying to plan their lives. Second, early litigation is often highly unremunerative. We're talking about junior lawyers essentially surviving on instant noodles and pure grit. This directly disadvantages academically brilliant candidates who just don't have a financial safety net to survive 3 years of low-paying practice just to take a test. So, ironically, rather than widening diversity, it might actually narrow it. Furthermore, regarding the district judges, critics argue that letting in-service officers use the bar quota actually reduces the number of posts genuinely available to current practicing advocates, which is wild because that is the exact group the quota was originally designed to protect.
And that leads us to our final section, Section 5, the need for stability, and our big picture takeaway.
The overarching theme here is super clear. Experience is prioritized, but oscillation definitely has a cost. Both the 3-year rule for civil judges and the 7-year prior experience rule for district judges reflect a highly coherent preference by the Supreme Court. The court clearly wants experience-linked judicial recruitment over purely academic or seniority-based entry. But, and this is a massive but, the constant back-and-forth changing of these rules over the past decade is highly problematic.
I want to read this quote directly from the source analysis because it just perfectly captures the stakes here. Repeated judicial correction of eligibility criteria imposes real costs on aspirants and risks undermining the predictability recruitment processes are meant to provide. Aspirants simply cannot hit a moving target. If the judiciary wants the best and brightest minds to serve, those minds need a stable, long-term policy they can actually rely on while preparing for their careers.
Which leaves us with a final provocative thought for you to ponder. How do we balance the undeniable demand for highly experienced judges with the absolute constitutional need for a predictable, accessible, and diverse recruitment process? There are no easy answers here, but understanding these rulings is the first step. Thanks so much for diving into this explainer with us, and keep exploring the structures that hold up our legal system.